Chief Justice, Associate Justices, may it please the Court. My name is Jamie Chalgren, and I represent appellant petitioner Mr. Marvin Cannon in two matters before this Court. Mr. Cannon filed a petition for writ of habeas corpus alleging ineffective assistance of appellate counsel alongside a appeal of the partial denial of his 3851 claims. I have saved 5 minutes for rebuttal, and I would like to speak to the petition of writ of habeas corpus, and if this Court and time allows, I would speak to Issue 1, subsections 2 and 3. This Court should grant Mr. Cannon a new guilt-phase trial because appellate counsel rendered ineffective assistance when he failed to challenge the trial court's ruling that the prosecutor had race-neutral reasons for striking 3 African-American jurors. I would like to preface my argument with reminding this Court, as stated in our brief, that the Florida Legislature's Office of Economic and Demographic Research shows that Gadsden County has a supermajority of African-American citizens. They have a majority of 56% African-American population. When we compare that statewide, we see that only African-Americans make up 16% of the population. So I think this Court would be remiss not to keep that in mind as I go through this argument. The issue at hand was preserved for appellate counsel. The trial counsel made contemporaneous objections in real time as the state attempted to strike the jurors, and then they did make a objection then again before the jury was sworn. Because of that, the standard here for this claim is the analogous Strickland claim, which says that I must prove that specific...
Can you show me where in the record there was the renewal of the objection?
Yes, sir, I can. It is on page Record of Appeal, Volume 8. If you look at pages 12 through 22, that is defense counsel raising numerous objections to these strikes. If you look then again, pardon me, page 22, the Court denies the defense motion, and then on page 29, the jury is sworn. So we're looking at a matter of pages 12 to 29 between the objections and the jury being sworn.
So what I understand, and correct me if I'm wrong, there's litigation on the day before or earlier in jury selection. 2 jurors a peremptory is lodged. There's a Melbourne challenge made. The trial judge allows the peremptory to go forward. There's a third one, and the trial judge says, no, I'm force-seating that juror.
That is correct.
The next day comes, and again, tell me if I have any of this wrong. The next day comes, the prosecutor says, Judge, I have the file from the prior, the prosecution I was referring to. I want to relitigate this. I want to remind you of this particular Florida Supreme Court case, and I want this juror to, I want to be able to exercise my peremptory. They litigate it again, and the trial judge says, I'm reconsidering my ruling, and I am now allowing the peremptory to be done. There's some talk about an alternate, because now there's no alternate, and then they strike the other alternate, and then there's some legal discussion about some other stuff, and then the jury is sworn.
That is correct.
Do I have any of that wrong?
That sounds correct so far.
Where is Your Honor, I preserve all of my objections and all of my strikes and everything that was done in jury selection, which you often hear right before a jury is sworn.
You do often hear that, and unfortunately in this case we don't have it, packaged in, the same way with a nice little bow.
How is that not violative of our statement over and over again that there needs to be that renewal before a jury is sworn?
Your Honor, the only difference I would say is that he didn't say it in the same way maybe that most people do. He, over 10 pages of record, is objecting vehemently.
So is your argument that the objection itself is the renewal?
Pardon?
Is your argument that the initial objections constitute a renewal?
No, sir.
So what else was said?
The defense counsel had requested to reopen voir dire, stating in particular that he was worried about the racial makeup, and asked the court to reopen since he was now removing this third African-American juror. Defense counsel then asked to reopen it because he's very concerned now that we only have one African-American juror. He says, open this back up, let's bring in new jurors, we need to start this over again.
And the trial court denies that.
That is correct.
And that's it.
That is correct. Although he doesn't say the words, I'm maintaining my objection. The entire objection throughout has been about this issue.
So the reopen, what you're saying is the reopen is the renewal. What we traditionally would do is,
yes,
Your Honor, I renew all my objections and strikes and everything else from jury selection.
Yes, sir. And unfortunately, this trial was a little lax in that. The judge never asked. Parties didn't really state on record that they were preserving, but that is my assertion, Your Honor, that was his.
If we disagree with you on that, is that problematic for you on this claim?
It is.
Okay. Thank you.
Thank you.
And what did counsel do to rebut the race-neutral reason that the state put forward?
The state? What did the state do?
No, I mean, what did your client's counsel at trial do to rebut it? Because, I mean, the reasons given were obviously race-neutral, and so then you would still have to then show that that was pretextual, right?
Right. The reasons given for, defense counsel, I'm not recalling right, immediately. I do know that the state put forth pretextual. Oh, that was the argument. That the state's reasons were pretextual, that they weren't really race neutral.
The question was that argument made by defense counsel? Did defense counsel argue that this is pretextual? So he said, I'm asking for a race-neutral reason. One was given. It was race-neutral. Was there any additional argument as to why that was not a genuine?
I don't recall if there was more argument, Your Honor.
I mean, because that would be significant, correct?
That would be.
It's necessary, isn't it? I mean,
I think I'm on track.
I'm sorry, the trial court has to be, once the trial court hears a facially race-neutral reason, which clearly there was here, then the burden is on the person who has a problem with the.
I recognize now. You're asking if the court did the Melbourne inquiry?
Well, did the burden shift to the defense counsel to say, no, that's not a race-neutral reason because of X?
Correct. Well, actually, I'm not so sure that defense counsel raised the same objections that I'm raising. I would assert that if you look at jurors Jones, Byrd, and Martin, we see that when the burden shifts and the state is asked to give race-neutral reasons, we see that the state points out that Jones has a brother that was sent to prison. Byrd has a daughter who was sentenced to prison and also knew the defendant, I believe it was.
But counsel, doesn't the statement you've just made that defense counsel did not make the same arguments that I'm making now, isn't that, I think that's what my colleagues are asking about, isn't that problematic?
It's not problematic. The issue is that the issue had to be preserved, which my argument is that it is.
So your argument, I think your argument is under Hayes, which we have not quite overruled yet that I understand, making the Melbourne challenge preserves the issue, and then the trial court has to independently evaluate genuineness. Is that your?
Correct.
Okay.
Yes.
But if the trial court is not made aware of what you're saying, how could we then say that the trial court was off as a matter of law on the genuineness inquiry? In other words, if no one told them, hey, judge, jurors number 1, 2, and 3 had the same thing, then how is the judge supposed to know and remember and weigh those things?
I understand. I don't honestly know.
Okay. Well, okay. Let's assume that the judge is supposed to do those things.
Mm-hmm.
As I understand it, the jurors you just mentioned, while there was some prior convictions,
correct,
none was a felony, none was as serious as the ones that the 3 that were struck, and 2 of them I think were out of state, or at least out of the jurisdiction here. Because part of the issue was not only did these people have relatives that were prior felons, but that they were felons that were convicted by the very office that was prosecuting this defendant.
That is correct. The state did put forth that one of the reasons was these convictions, and because they came out of their office.
Right.
But they did seem concerned with convictions overall. But they didn't seem concerned when it came to DUIs. And what an experienced prosecutor, an experienced capital prosecutor knows is that DUIs are often accompanied with great bodily injury, manslaughter. There's a chance that the DUIs that were stated by the non-African American jurors could very well have been involving incarceration.
But a DUI is, first of all, I mean, we all agree that they're generally misdemeanors, only if they include those things are they felonies.
I believe a first time is a misdemeanor, if not enhanced.
And second time and third time, and only the fourth time are they felonies. But
it's been a while since I've been in trial court, but that sounds correct.
But even putting that aside, that is categorically different than a lewd and lascivious molestation, which resulted in a 25-year sentence, a drug trafficking offense, which resulted in a 5-year mandatory minimum. Aren't they categorically different than the 3 that were not struck?
They are, if they are in fact DUIs, but the point that I'm making is that they didn't care enough to even ask. Certain jurors, I believe it was Bentley and Oriana, they weren't even asked the names of their relatives. You could kind of tell by the record that the prosecutors are probably going and looking as we're going along, checking to see if they've got a file on these people. We get to these white jurors, and they're not even asking the names of their relatives to be able to look up their offenses to see if they were in fact adjudicated in their jurisdiction or if they were felonies or whatnot. So,
well, let me ask it this way. There's no evidence to suggest that those other ones were prosecuted in the jurisdiction, right?
One of them was?
Yeah, the DUI.
Correct.
But the other 2, there's no evidence of that, right?
That is correct.
Yet we have evidence of the 3 that were struck.
That is correct.
Isn't that substantively different?
I don't believe it is. I believe that the fact that they did not even take the time to ask these non-African American jurors the facts of their family members' either incarceration convictions, that shows that they were racially motivated in their selection of the jury. Turning to Issue 1, Subsection 2, Mr. Cannon moves for ineffective assistance of counsel failure for failure to object to and moved for mistrial for law enforcement identification of the defendant. During the trial, investigator Robert Maxwell testified that he was a law enforcement officer for approximately 20 years. He talked at length about the investigation. Then he said he had known the defendant for years and proceeded to identify the defendant in a video. In closing arguments, we hear it reiterated again where the prosecutor reminds the jury that Maxwell recognized the defendant in the video. And I know you're probably thinking, well, where's the harm there with all of the evidence? But what they do in having the officer identify the appellant, Mr. Cannon, is 2 things. We have the invading the province of the jury. We also have an improper...
But there's tons of case law which says that if they have independent knowledge of what someone looks like, someone's able to identify under their lay opinion. I mean, there's tons of it.
That's correct, but they are not allowed to identify themselves as law enforcement unless that's going to help the jury. It didn't help the jury when they can see that he's wearing the same clothes that he's arrested in. So thereby they have invaded the province of the jury, Your Honor.
How's that possible? If the evidence is I've watched that video, I investigated this case, and I've known that guy for 20 years, and I'm able to say that is John Smith, how is that not relevant and not appropriate evidence? I mean, isn't there case law stating exactly that's appropriate?
No, Your Honor, and that's the other side of this is that it's a character evidence ban violation, that he gives the inference that he knows the defendant when he says, I've known him for 20 years, that's him in the video.
All right, so you have the statistics there in Gadsden County. How large is Gadsden County?
That I don't know. I only know the population.
It's not large, right?
That's my understanding from the record that everybody knows everybody.
Okay, so I was about to ask that, because in the jury selection, there are a lot of people who know moms and dads and brothers and sisters, right?
I think it's the only record I've read where there's a relative of both the victim and the defendant and co-defendant on the panel.
So given that context, how can we infer that the statement of, I've known him for years is, he's a bad guy and I've arrested him 20 times, which clearly would be wrong, versus, I've known him because we all know each other. It's a small community. Well,
we don't necessarily think, not everybody knows everybody. We've gotten to this point where we've cut the jury down to 12 people who don't know everybody. And that was the point of the jury selection, to try to get all these people out. So we're down here with a panel of 12 people that don't know Mr. Cannon. And I don't believe anybody knew Mr. Maxwell as well, or they were struck. So what we're left with is a jury that doesn't know the defendant, doesn't know the investigator, and they hear the investigator say, I've known him for 20 years, that's him in the video. They are left with a reasonable probability that they are left with the impression that he's been involved in criminal conduct for 20 years, and that's the problem. I would also like to briefly address Issue 1, Subsection 3.
Other than the fact that the officer said that he knew him from prior contact. Is there anything else that would, in the testimony, that would indicate that that prior contact was based on criminal conduct by the defendant?
No, Your Honor, just the fact that he...
So if we accept your argument, it would be a rule of evidence that a law enforcement officer could never be used to identify anyone if the basis for the prior knowledge was their criminal conduct.
And that may well be true, Your Honor, but in this case we have Mr. Maxwell who testifies at length about the investigation. He was the lead investigator. He talks about his working in law enforcement for 20 years. This is pretty much the gamut of his testimony, the investigation of the case, and then he goes into identifying the defendant on the video.
Is there anything different that he could have done to identify the defendant?
He could have not identified the defendant, first of
Right.
all, because he was wearing the same clothes in the video that he was wearing when he was arrested. So I think everybody could make that match up themselves.
But you're not suggesting that the evidence wasn't relevant so that it wouldn't otherwise be admissible.
That is correct. If there are no further questions on that issue, I would turn to issue 1-3 real quickly. Ineffective assistance of trial counsel for failure to object and move for mistrial for burden shifting. Real quick, Your Honors, what we have is a situation where the state says in closing, I also thought it was very interesting that the defense presented Mr. Johnny Cannon. Did you hear Mr. Johnny Cannon testify? Oh yeah, there was corn out there, they just didn't see it. That's where I put the corn. Did Mr. Cannon say anything like that? Your Honors, is my assertion that when the prosecution said that they improperly shifted the burden,
Where the defense put in an alternate theory. So the state's theory was there was no corn, they brought him there to be murdered.
Correct.
The alternative theory for the defense was there was corn there, but the reason they didn't see any corn when the police got there was that it was days later until they actually did an inspection to see that, and the corn could have been taken or sold or anything could have happened to it,
That's
right?
correct. That was the defense's theory,
Right.
and what the defense tried to point out.
So why can't you point out of lack of why can't the prosecution point out of lack of evidence for that theory?
Because what the
That
state,
alternative theory.
Well, we're kind of getting into like a double negative. The defense had pointed out a lack of evidence
Right.
as to an element for the state, and the state comes in and says.
But part of the background for this, there was some testimony that there had been a surge by the officer an officer who initially went to the crime scene.
Oh, correct.
And that note of corn was found.
Correct, but it was late at night and it was dark.
No,
Well, I
Officer
understand
Maxwell
that,
was
but
there.
there was testimony, right?
Yes.
And wasn't Officer Maxwell's testimony that he arrived during the daytime hours? He was there for 8 to 10 hours. He did a search. He never saw corn at any point when he was there. There was another officer that was only there at night, but Officer Maxwell's testimony was about a long period of time, that including daylight hours, correct?
It's correct, but it was also after the event. It's my understanding that the scene
Well,
was...
after the event was that the scene was discovered almost immediately after the murder.
Yes.
So
In the middle of the night is my understanding.
The point is the defense put on an alternate theory to rebut that.
Yes.
Isn't the state allowed to say, there is no evidence, you heard the testimony of this witness, there is no evidence to support that alternative theory?
Not in this situation, Your Honors.
Haven't we said that exact thing in Scott when almost the identical thing happened?
Scott v. State, one moment, Your Honor, let me pull that
So
up.
it was a recording, where he admitted it in a jailhouse recording. The defense theory was they scripted it and they didn't say. And then in closing, what they said is, you don't hear any evidence to support that alternative theory.
Your Honor, and I recall Scott now, that is a case of invited response, if I remember correctly. But this is not a situation of an invited response because it's kind of like the defense pointed out the negative and...
No, it wasn't the negative. The defense said it was probably something happened to this corn. That's not the negative. There's no evidence to support it. It is something happened to the corn.
My point is the defense is pointing out the lack of evidence from the state. The state cannot then come in and say the defense didn't prove one of these things. That is shifting the burden onto the defense.
Counsel, you have used all but about a minute of your rebuttal time now. You can keep going.
I would just take any other
Mr.
questions that there might be. I know it's late in the day.
But didn't Mr. Neal also testified that there was no corn? I mean, one of the victims who survived.
Yeah, that may be true, Your Honor, but I don't know that he would know. Unfortunately, he arrives at the property and he's immediately attacked. I don't know that he had time to go out and look over the property once he was attacked and jumped out of the truck.
I'm sorry to interrupt
Yes,
you.
sir.
Just a quick question on issue 1-1. The alleged
1-1?
problem with those jurors had to do, it seemed to me, more with the penalty phase issue. I mean, are you still sticking with that claim, or do you acknowledge that that's moot?
Your Honor, I would just, I would point to the brief for that, Your Honor. I would
Okay,
rely on
well-
my brief for that argument.
Okay, but you didn't really address this, the question that I'm asking you in the brief. I mean,
Mm-hmm.
what the problem that you identify with the jurors is that they, you know, once they've found that someone had committed a murder, that they would be predisposed to give them, to recommend death. And since you're getting a new penalty phase here, why do we need to address that?
Your Honor, I feel that the prejudice that we saw that affected defendant's penalty phase directly flows over into the trial phase. Usually things, if a person is biased, they are not going to leave that aside in the different phases. So that would be my answer, Your Honor. Thank you.
All right, okay, you've used up all your time. I will nonetheless afford you 2 minutes for rebuttal if you want.
I don't think that's going to be necessary.
Okay,
I would
that's
just
fine.
ask that this court grant Mr. Cannon a new guilt phase trial for the reasons stated. Thank you.
May it please the court. My name is Lisa Hopkins. I'm representing the state in this matter. First, I'd like to address the habeas petition. The ineffective assistance of appellate counsel. The standard is synonymous with the Strickland standard, prejudice and deficient performance. It's the state's position that appellate counsel did not render deficient performance for failing to raise a meritless claim. In this case, when a race-neutral reason is requested for a peremptory challenge, the court is in a unique position to determine whether that reason is pretextual. And regarding to Jones and Bird, regarding Mr. Jones, they had sent his brother to prison, and there was a claim that the brother was not guilty. Regarding Bird, they had sent her daughter to prison, and additionally, her daughter was related to the defendant.
But wasn't there evidence to suggest, if you were to go through the Neil Slappy factors on the genuineness side of things, that there were people, at least somewhat similarly situated, who were not struck, and those people were white, and the jurors that were struck were African American?
The state actually put on the record that there were African American jurors that they had accepted.
That's certainly one factor
Correct.
that's there, and that the defense had struck, I agree. But ultimately, those were not in the juries because there were other problems with them. But the point is, at least on similarly situated individuals, those that were white were not struck by the state, those that were African American were struck. Doesn't that go to the genuineness finding?
It can go towards the genuineness finding, and that is the vantage point of the trial court to determine whether it was genuine. Regarding the white jurors, you mentioned the DUI. That is a misdemeanor. It is not, in fact, a serious felony such as the lewd and lascivious, which Ms. Martin had stated that she had hard feelings regarding. Her son had been sentenced to 25 years followed by lifetime probation. And the arguments that were made went more towards a for-cause challenge, which is not the same standard as a peremptory challenge. Because the court ultimately looked at the case law that was provided by the state the following day when they renewed their peremptory challenge, requesting that Martin be struck, and the court was able to made the determination that it was a genuine race-neutral reason, and that...
What do we make of the fact that the court, at least initially looking at it, paused and thought the other way? Doesn't that indicate that there's some merit?
I think the court was applying a cause standard because the court's analysis discussed, well, yes, the son was sent to prison, but the daughter's case was resolved in a way that Ms. Martin found favorable. That's an analysis for determining whether there's cause about whether someone could be fair and impartial. Peremptory challenges are presumed to be race neutral unless there's reasons given that show that it was pretext or that it was exercised in a way that's in a discriminatory manner. In this case, it's the state's position that the state did not exercise these peremptory challenges in a discriminatory manner and
Do you agree, or do you agree with your colleague on the other side that the motion to reopen was in the nature of a renewal of objections?
I would disagree with that. I would say that it was not preserved and that...
Did the state make the preservation issue in its response to the petition?
No, Your Honor. But even looking, had this claim been raised in the direct appeal, it would have been meritless. It would have, even if it was not preserved, it would have been addressed under a fundamental error standard, and this would not have risen to fundamental error.
How would it have been fundamental error? Because if it was preserved, in other words, we put preservation aside.
Well, I'm saying if it wasn't preserved, then
Okay.
that would be the standard that applies. And if it was preserved, it's still a meritless claim, given that the court was able to determine that this was not pretext and there were race-neutral reasons.
Let me ask you one question about that. With respect to the Melbourne or Neil Slappy inquiry, there is confusion in our case law, I think, Hayes on one side and Floyd in other cases on the other, about what's required of an opponent of a peremptory challenge in order to preserve that issue. Do we need to resolve that conflict in order to decide whether this issue was preserved on the habeas question?
I think it should be resolved, or clarified, not necessarily conflict, but just clarified that what exactly is needed to preserve this type of claim, because it was reopened the following day before the jury had been sworn. There is some question about whether or not this actually was preserved.
But again, you didn't make that preservation argument in the response, right?
That's correct, Your Honor.
Okay.
But I think he was asking, though, I thought, about the issue, not about the renewal aspect,
Right.
but about the issue of whether there's a burden on the opponent of the strike to actually give the judge the reasons for why it's pretextual, as opposed to requiring the judge, him or herself, to kind of figure out why it might be pretextual.
I think there is a burden that once the state gives a race-neutral reason, that there is a burden to overcome that, because there is a presumption in favor of peremptories being exercised in non-discriminatory manner.
So the answer to the question is, he was asking if you think that that's something that is already the law, or if that needs to be clarified.
I'm not sure, Your Honor. I'll be honest.
But again, I just want to be clear, that preservation argument, that separate one of whether you have to separately object on genuineness grounds or not, was also not raised in the response, right?
That's correct, Your Honor.
None of this we're talking about right now
That's
was
correct, Your
litigated
Honor.
in this case.
That's correct, Your
Okay.
Honor. In addressing in the actual appeal, Claim 1, Subsection 2, regarding Investigator Maxwell, Investigator Maxwell testified that he personally knew Mr. Cannon for a number of years. He didn't actually state a number of years. There was no testimony as to how he knew him, in what context that they had come in contact before. Mr. Garcia, defense counsel, testified that it was common that people in this community know each other. Gadsden County is a smaller county. It is a much smaller population, and it is common for people to know each other. As the record clearly reflects, many of the prospective jurors knew officers, knew the defendant, knew the co-defendant, knew the victims, and while many of those prospective jurors were removed, it is still common for people in that community to know each other. That is common knowledge. It's the state's position that and the trial court, the post-conviction court, was correct in finding that there was no prejudice regarding this ineffective assistance of counsel claim, given that it is common, and the fact that Investigator Maxwell was able to personally recognize him did not cause prejudice because, well, one, Mr. Cannon was arrested a few days later wearing the same exact clothes that he was seen on the video. there was overwhelming evidence.
And is co-victim identified the murderer here?
That's correct. Mr. Neal did identify Mr. Cannon as the person who stabbed him and as the person being involved in this murder. So when looking at the whole of Investigator Maxwell's testimony, there was no highlighting that, well, this came from prior bad acts. There was no character evidence. It was just, I personally know him. I know who he is. They already had an idea of who they were looking for at that point based on where the incident happened. It happened on the Cannon's property. The fact that Mr. Neal was able to identify Marvin Cannon as the person who was being involved in this case. And ultimately, the victim's blood was found on Mr. Cannon's clothes. Mr. Morgan's blood was found on Mr. Cannon's clothes when he was arrested a few days after. So the post-conviction court was correct in denying this claim. In addressing the burden-shifting claim, Claim 1, Subsection 3, this was a permissible comment on the evidence. The comments about Johnny Cannon did not come in until the state's rebuttal, and in this case, it was a response to the closing argument that was made by defense counsel, in which he argued that, well, we don't know what happened to this corn. It could have been taken. We don't know. And that was a feature of the defense's case, is that we don't know what happened. We're not sure. They put all the blame on the co-defendant, Anton McMillan. In this case, the corn, that was a motive to get the victims onto the property, but ultimately does not prove or disprove whether or not Mr. Cannon is the one, in fact, who committed this murder. And it's based on Mr. Neal's testimony, the finding of the victim's blood on Mr. Cannon's clothes, Mr. Morgan's wallet being found on the trail when the K-9 was tracking him. All of that testimony, whether or not there was corn on the property, does not go towards whether or not Mr. Cannon is the one who, in fact, committed this murder. Even under a principal theory, they were working together, clearly, because Mr. McMillan also, they were able to recover the knife, part of which was found in the victim's head. If there are no other questions, I am asking that you affirm the post-conviction court's order and deny the habeas. Thank you.
All right. We thank you both for your arguments, and court is now adjourned. All right.